Yes, Mr. Haddon.
Yes.
We don't need to hear you on grounds 2 and 3,
Yes.
but we do want to hear you on grounds 1 and 4, and the same will apply to Miss Watson and you.
Very well, and
Right.
thank you for that indication. Also, before I start, we've had a request from observers who are observing via the live stream on YouTube whether or not we could release our skeleton arguments to them. Now, my understanding is that's a decision of the court. It's not one for me to agree to.
The only trouble with it is that some of the names are not redacted. I looked at Mr. Lawson's skeleton argument. It doesn't identify PC and her mother, but it does identify some witnesses.
Yes. The request has come from someone who observed at first instance, Professor Celia Kitzinger.
Yes.
She is aware of the terms of the transparency order that was made at first instance. If she's been following from the outset, she now knows that also these proceedings are bound by the same terms. But on that basis, knowing that she cannot disclose the identity of the individual's names,
I mean, of course, I know that Professor Kitzinger. Sorry, I should say. So I was just saying that, and I know, of course, Professor Kitzinger wouldn't dream of disclosing or revealing the identities. Of course, she wouldn't. But I'm just always a bit nervous that once something's gone electronically and is in the ether, it is indeed there. And I just think, really, for her own protection and for certainty for all of us, I would feel more comfortable if those behind you or someone could redact. I don't think it's a huge task if each of you, each team, did their own check or redact and then sent it through to her. I just would, without being in any way pejorative, I just would feel more comfortable personally.
My lady, I share the same disquiet. So yes, if that could be arranged.
But subject to the redactions being made, there's no reason why the skeletons shouldn't be released, certainly to Professor Kitzinger. Yes.
Thank you.
Right.
I don't know if it's feasible for that to happen as I'm on my feet, but in any event, if it can do, then otherwise we'll send them at the end of the hearing.
Yes.
I don't think you'd expect them now when you're on your feet.
No. So, my lady, my lords, in respect to ground 1, as has been indicated, the legal principles around the test for adjournment, that's agreed. In addition to that, it's also worth bearing in mind, of course, this is adjournment for a purpose, which was to obtain expert evidence, which imports a further test of necessity. And so I say that again, that's not controversial, but it's when bearing in mind whether or not it's fair or whether it was unfair to continue the hearing, then it's part of the consideration as to whether or not it was in fact unfair, as to whether or not that threshold has been met regarding expert evidence. The ICB submission in respect to that, of course, it was met to the extent that the court concluded it was not necessary. So the court applied, Mr Justice Cusworth applied his mind to the test, and in light of the evidence he had, the totality of evidence, he concluded it was not necessary to obtain further expert evidence. My learned friend Mr Lawson has suggested that there was non-compliance with the PDOC guidance, if I can call it that. And if I could just take my lady, my lords, to some relevant parts of the guidance around the assessment point. The high point, if I can call it that, of Mr Lawson's submission on this is, it starts at page 131 in the authorities bundle. Which identifies, so it's internal page 47, page 131, which says formal assessment is essential in the following circumstances, and it's the third arrow as part of the assessment when making decisions about the potential withdrawal of active medical treatment, specifically CANH. Pausing there, and I say this is the high point in terms of the guidance. Pausing there, it doesn't say when that assessment needs to have been completed. It doesn't say a recent assessment. It simply says an assessment that should form part of that. To contextualise the guidance, and Professor Wade touched on this, is that it's not only for specialist centres like the RHN, it's also for individuals in PDOC in a care setting that have perhaps not had a formal diagnosis, that this guidance was intended to both educate and motivate such centres to, if there hasn't been a formal assessment, to undertake one. And there are places in the guidance that set out that. However, to suggest that when making an application to court for a determination of a patient's best interest regarding this issue, that you require an up-to-date assessment, I say it doesn't say that. For the following references, I've already taken, or my lady, my lords have been taken to the reference about reference to if there's clinical uncertainty.
Sorry, before we leave page 131, the third of the 4 bullet points. Formal assessment is essential in the following circumstances. As part of the assessment when making decisions about potential withdrawal of active medical treatment, specifically CANH.
Part of the assessment, and what I'm trying to hone in on is if that assessment's already been conducted, if there's sufficient clinical certainty, which I do say exists in this case, then that will need to be factored in as part of the best interest decision-making process. But what it's not saying is that if you've undergone the structured assessments as well as an expert diagnosis from an expert PDOC clinician, that you necessarily need to repeat it just because you're going to court.
And you say it was done in 2020?
Well, yes, if I touch on that. So in terms of there's a number of different elements. There's the structured assessments, there's the WIM test, there's CSR. There was also a Matadoc test, which looks at different responses to sensory stimulation. It's in E1 to 49, that's the full amount of the assessments. In total, and I'm very grateful to those sat behind me who've done the maths on this, in total there were 37 assessments over a 3-year period. 25 of those were in the initial phases when PC was in the assessment and rehabilitative ward.
So 2020.
2020, moving to March 2021. And then what followed, there'd been a further 13 assessments between 2021. There were 2 WIM tests in 2022, and then 5 WIM tests 2023, and then 2 further CSR tests in 2023. So
The last one being when?
the last one was, I understand, was October of 2023.
So 37 tests in all.
Yes. And those are just the structured assessments. Of course, one has to recognise that's not the complete picture. One has to look at the totality of an individual's experience, being cared for by those who have expertise and experience of caring for patients with PDOC. Is there any clinical signs of change of responsiveness, change of awareness? So there's environmental factors which may then lead to a trigger for further reassessment. But throughout this period, PC has been in one of the leading centres in the UK for treating patients with PDOC. So my submission would be is that if just on an environmental basis, if there was any change to PC's level of awareness or responsiveness, she's in the best possible setting for that to be detected.
Do we have a clear, as it were, picture of how of any pattern in change or non-change over those 37 tests?
No, that they are all consistent with the diagnosis of MCS minus.
So we have the picture that they're consistent. as it
Yes.
were.
Yes.
There's no evidence of any change.
No.
The picture we've got from, we haven't drawn them, Mr Lawson, but the picture we've got is that there were isolated ticks in a fairly large pool of crosses.
Yes. Yes.
If we were to, do we know, have clarity as to what the position was? Would that be the picture? Ticks may be different, but they would still be isolated ticks in a pool of otherwise.
My understanding, my lord, is that the isolated ticks, one that Mr Lawson's drawn your attention to, but the other is a reference to a smile in November 2020. It may be helpful to particularly look at what it actually says, because it's slightly more nuanced than that. If I can take you to it.
We've got quite a lot of blank pages in our copy.
Yes,
the lady mentioned earlier.
it's in the original summary, so that's at E1 through to 7. So I don't need to take you to the underlying assessment, but it's at E2 in particular in the supplementary bundle.
E2.
E2, yes.
Yes. Ability to smile, stick out tongue.
That's right.
Yeah.
That's right, my lord. So this is the single reference to a manifest behaviour, manifest pleasure behaviour, if I can, perhaps that's a very clunky phrase, but it demonstrates an experience, well, potentially demonstrates, but even then I'd submit that based on that description, it's demonstrating ability to smile / stick out tongue to verbal command, but this was not always reproducible or consistent. That's the only evidence we say of overt experience potentially of pleasure in the sense of manifesting itself in a smile. But to return to your earlier question, my lords, regarding the other indicators, what I can say is this: is that there are no further instances like that. They're all consistent with the clinical diagnosis of a minimally conscious state minus. In terms of then whether the PDOC guidance requires structured assessment if you're about to make an application to court or in the event of a disagreement, if I can take you to the broader summary, and that's at page, it describes the ethical framework, and it starts at page 206. And you'll see it's, I don't know if it's come out in your copy, but it's highlighted purple. But it sets out here the ethical and legal framework for decision making, and it provides a summary of recommendations. My submission on this is that there's nothing in this framework which suggests that you have to undertake structured assessments, or repeat structured assessments in order to make a best interest decision. What is necessary is a clinical diagnosis. And in particular, that's reinforced if you turn to page 208 and paragraph 4.9, which is applicable to PC's case. So decisions regarding life-sustaining treatment, including CANH, in the absence of a valid and applicable advanced decision. And then it says paragraph 3, patients should have an expert assessment, provide a detailed evaluation of their level of awareness to record any trajectory towards future recovery and deterioration. Again, that's set in the context of to cover those patients that may not have never had such an assessment. They've maybe been in a care setting which didn't specialise in that.
Patient should have an expert assessment as set out in section 2, and section 2 says formal assessment is essential in the where you're making an application to withdraw.
Yes, and my
So it
submission
is, it's by cross-reference, it is referred to.
in respect of that, but that's in the if no such expert assessment has been undertaken prior to that point, if there's been any any sign of clinical uncertainty, then again it does require structured assessment.
Wouldn't the 2020 observations assessment, that was when PC was first in the hospital?
It was for over a period of 5 to 6 months.
Yes, but this is not a statute, but I would have thought isn't that to establish initial diagnosis and behaviours as a baseline to guide future management?
It's also, well, it led to her being discharged from the ward because Dr. B, who is a leading consultant in neuro rehabilitation, he was satisfied based on the structured assessments and the overall evidence, the clinical picture, to make a diagnosis of the fact that PC, in his judgment, was he could provide a permanent diagnosis of MCS minus. The reference to that, to complete this, is it D23 and paragraphs 33 to 35.
And then we've got at D26 and inferred investigations. That's what we referred to this morning.
Yes,
Relating to disordered consciousness, we recommended lesser presentation change. And I get all that. I absolutely completely see that, because then she's in a specialist care home, she's got these expert nurses, you know, the GP runs it, is hugely experienced,
yeah,
and specialised. So I get all that.
yeah.
But what I'm getting from the guidance, and you're telling me I'm wrong, is that that's absolutely fine when you're ticking along in that situation.
Yes.
But if it's decided by the clinicians the time has come to think about withdrawing hydration in her best interests,
Yes.
my reading the guidance is then that is so significant, that is going to bring her life to a close in circumstances where otherwise her life expectancy could be up to 10 years.
Yes.
At that stage, before making that critical decision, you have to do an updated assessment. Now, tell me why I'm wrong, either on my reading the guidance or logically.
It's whether there's. I submit it's driven by clinical. The purpose of a reassessment is dictated by clinical uncertainty. So if not in these circumstances. It's governed by the fact that if you are making an application to a court to withdraw nutrition and hydration, yes,
then it is so important
yes,
that no matter how clear one is actually on one level,
yes,
you have to have a fresh assessment so that the court can be absolutely clear what the current up-to-date position is with the patient.
Well, if I can turn to page 210 of the guidance, it expressly deals with applications to the court.
Right.
And it's just over the page of 210 at 211, which is in my submission the relevant paragraph. It says, if the initial decision, so that's decision, the best interest decision, appears difficult because of uncertainty about the patient's level of awareness or their prognosis for recovery, making a balance of benefits and harm, it may be helpful to refer them to a designated specialist PDOC centre for more detailed evaluation, or to seek a further opinion from a senior PDOC expert with substantial experience of prognostication of best interest decision making. So there you have the requirement. If you're going to court because if there's a dispute around best interests, it's referring you to a specialist assessment within an expert PDOC centre.
As I understand the passage we're looking at here, it's not in colour as you say, but these are the recommendations.
Yes.
Is there further discussion of these points earlier in section 4 which would shed light upon the point we're asking you about? Have I got the structure right? So the section 4 is headed ethical and legal framework for decision making. We're looking at the recommendations. Is there any clarification or assistance earlier on?
No, my lord. As I said in my submission, the high point, as it were, is the passage that Mr Lawson took you to regarding the need for an assessment. What I'm trying to demonstrate, if you read it contextually and as a whole, the guidance does not say that that is necessary. And in particular, if one looks at moving to, that was my end point, was if one looks at the applications to the court section, it's framed around questions of uncertainty. And what you have here is Dr. B, who formed a clear view based on multiple, one may even say above and beyond the required amount of structural assessments. You also have Professor Wade in 2 opinions as an independent second opinion who also reached the same view, and then also in all evidence. He said bluntly that further assessments would be a waste of time. It's also not a requirement for the second opinion doctor, the independent opinion, to also undertake or require further assessments, and the relevant parts around what the second opinion doctor should be looking at or considering is just above the section I've taken you to, pages 209 to 210. It certainly doesn't require the second opinion position as it's described to see up-to-date assessments if they, unless they feel it's warranted. Of course, they could request it at that point.
Well, can I push back, if I may, what you just said? Isn't it helpful to look further back in section 4 at the discussion, for example, and please help me with this if I'm in the wrong place, at page 195. The structure of this document is the chapters end with recommendations after discussion earlier on. And that's how I read it. Please tell me if I'm wrong. 4.7.1, 4.7 is about 194 is about life-sustaining treatments. Am I in the wrong?
No, this is to do with the proportionate. It said the proportionate within the section proportionate external scrutiny of decisions about life-sustaining treatment, including.
So am I barking up the wrong tree, or?
Well, that is relevant to second opinion.
Okay.
And external scrutiny.
I'm just looking, for example, at 4.7.1, the top of 195. And this, I was going to ask you about what is the current case law about this, and here we see Mr Justice Cusworth.
Yes.
This is presumably, I did a PL was decided, it's 5, that must be 5 or 6 years ago, must it? Because this is 2020. There's a lot of discussion about all this, isn't there? I mean,
yes.
The establishment of the level of awareness at the bottom of 195 goes over 196. Does this say anything about whether we need to retest on a structured test?
It does not. And whilst it's not relevant to the guidance, but more generally, my lady, my lords, you've been taken to the point of principle regarding the extent of investigation that may be necessary, as Mr Justice Jackson's example said in the case of Riem, which is that it's always, I'll take you to it directly. It is an abstract principle, I understand that. It's A21 in the supplementary bundle. But in particular, in Riem, it's said at paragraph 27, and it's quoted there at A21.
So, supplemental bundle.
Supplemental bundle A21, it's in the agreed summary of legal principles. And it's that quoted paragraph. In reaching this decision, I was mindful that this was in effect an application made by agreement. There are always more investigations that can be made, questions that can be asked, stones that can be turned. And he was satisfied the court had all the essential information and that further inquiries would not alter the fundamentals. And what's important is that those called upon to express a view should do so conscientiously, drawing upon their personal and professional knowledge of the individual concerned. So there's a view expressed that at some point investigations need to stop, and fundamentally, will further assessments alter the fundamentals? It's also right to, as I've started with, there were some further retesting, as I've identified in both 2021, 22 and 2023, albeit it's not the same NDT level that was completed in 2020, but there were at least 11 further structured assessments that took place following that original diagnosis. So it's not as if she's been completely without any form of assessment. Finally, Professor Wade was asked about this. I've referenced already what his evidence was on this, is that if I can perhaps take you to it in the transcript. In summary, he said that it's what his conclusion is D118 F. But it starts with the passage, and these are questions from my own friend Miss Watson. So he concludes by saying it would be a waste of time. That's his conclusion. But prior to that, the question was asked at T117Q. G. You've been quite clear in your report, Professor Wade, there are no prospect of any improvement in PC's condition. You say at the beginning of your report at T2, and then also other page references in the second report. And the question is there any hope that the individual may improve? Is there any chance in PC's case, in your opinion? He's emphatic in his response. He says there's no chance, I think, of any improvement at all. I think that others fluctuate day to day a very small amount, but in terms of being consistently better, no. I think it's likely to stay the same or get worse. And then being asked questions about in relation to an improvement in consciousness, he responds, and this is at D118, paragraph D, or section D. I think there would have been no significant improvement. I'd like to refer to it as responsiveness, really, how much PC responds to the outside world. And then finally, coming back to the same questions, this is section E of that page. Some of the questions that were put to you about the nature of the structured assessments that have been carried out in the past, and whether any further structured assessment carried out by an NDT team, is that likely to change the picture? He said, no, it would be a waste of time. So what you have here is almost putting the PDOC guidance to one side. You have an eminent expert saying it would not be necessary. Certainly wouldn't change his opinion on diagnosis or level of awareness. And that was his considered view after having examined PC on 2 occasions, over a period of about 10 months apart, and examined her medical records, spoke to the family, spoke to those caring for her. So this is a comprehensive look, assessment in my submission by Professor Wade. So in respect of that, my submission is that the PDOC guidance does not go so far as what Mr Lawson says it does in respect of requiring an up-to-date structured assessment as a precursor to any application to the court for this matter to be determined. The other aspect of ground 1, unless there's anything else to do with that point, I was going to move on to look at what's been said about the change of view by Professor Wade. You've already been taken to the relevant extracts in his first report and the second report, where it's said that he's reversed his opinion on pain. If I may also take you to the paper that was produced about a week or so before the final hearing. That's at page, it starts at D51. And concludes at D56. There's references as well. This is an unpublished paper, but it does, in my submission, demonstrate what Professor Wade is saying in respect of his view. In summary, before I go into some of the detail of that paper, as my lady, my lords, as you'd already were asking questions in this direction of my learned friends, his view of level of awareness does not change. His view is that pain, he's got an expanded definition of what pain may now amount to. Perhaps he would say, I was circumspect in the past because it didn't correspond with our standard definition of pain, but actually I'm now thinking about this and maybe we should have an expanded definition of pain, which is not dependent upon a functioning neural pathway. I've said this in my skeleton argument in paragraph 39, is that express recognition now that PC may have some experience of pain, and I've put that in inverted commas, should not be conflated with any change to his opinion regarding her level of awareness or consciousness. The reason I put it in inverted commas is because he goes on to talk in the cross-examination as to pain at some level. He describes it in terms that pain, but perhaps not as you or I may experience. And he does so at D68 of the transcript, so this is in the core bundle, starting at section E. He's being asked about his opinion on pain and what it may amount to. He talks about the evolution in his thought, continuing to learn, to continue to think about these things. And then over the page, sorry, one moment. Yes, so that's the sort of precursor to him developing his change of view as to what pain may amount to. And then if you go over the page at D71, at G, Now the question's asked, if you had to decide on the balance of probabilities, you'd say it was unlikely, but we can't exclude the possibility. His response to that was, I think I would now say, having done some research, even since the March report, that it would be difficult to say that she's not experienced pain at some level in some way, as we've just discussed. And then I think it was my lady that also referred to the passage at D72, section B through to C, which says, I think one has got to separate out the extent of the experience against the experience. So I'm arguing it is possible, I would say probable, that there is some sensation of pain, but I cannot say what that sensation would feel like. I'm informed by Dr. B, who has been following this online, that he said one possibly helpful way of conceptualizing this is to understand pain and awareness as being co-located. He says that if it helps and assists the cause, that the neural networks for pain and consciousness are co-located. So if one is damaged, it's likely the other is. He then qualifies that a bit further by saying, well, that that's not a definitive description. Science simply doesn't take us that far, but they do interact in that way, but they do need to be considered separately.
That's what Professor Wade said.
Yes, indeed, and that's actually what his paper says, because what he identifies just before his conclusion, and just turning back to that, says that this is at D55 in the core bundle. The question is asked, how much pain do patients experience? And again, he's describing patients in PDOC. They do experience pain at some level. That's the third paragraph on that page. The most apparent is their pain behaviours. But also, secondly, he refers to the nociceptive structures as being evolutionary basic and deeply embedded in the body, and they resist damage, which again, my lady picked up on that in his report. But then he goes on to say, well, such two arguments suggest that pain can be experienced minimally. One is the complementary evidence of a low level of awareness, and the second is the degree of memory, because if that's impaired, if you typically, if you or I were to experience pain, we may recoil from a similar circumstance in the future, whereas he's saying that that's not present. So what he's describing here is a much broader category or understanding of what pain may amount to. But he's not fundamentally, for this case, saying that there's any change to PC's qualitative experience, or more crucially, her level of awareness. And in any event, if, as it was in this case, his evidence was accepted that on the balance of probabilities she is experiencing pain, however now described, that only of course leads to attaching greater weight in any best interest analysis. So it only points in one direction. That's what I'll come on to when touching on ground 4. There's no equivalent evidence before Mr Justice Cusworth that pointed to behaviours that indicate pleasure or indeed comfort. So in any event, that change of opinion or that deeper level or understanding of pain, it only points in one direction.
I struggle with the idea of anyone being able to substantiate the submission that she was comfortable given all the evidence about her crying.
Yes. Yes.
You know, whether that is some abstract form of distress that we don't understand, whether it's actually pain induced, we just don't know. But you know, someone that's constantly crying
Yes.
is not comfortable.
No, and certainly I may be straying a bit too far on this, but that's my understanding is it was PC's own presentation which prompted Professor Wade to think about this issue further, because the pain and distress behaviours were so manifest that he did not feel comfortable in simply saying, well, on the balance of probabilities, it's unlikely or even very unlikely. I'm also reminded of my lady's judgment and my Lord Justice Baker's judgment regarding the issue of pain, and even if the court weren't able to make a finding on the balance of probabilities that pain were present, that still does not mean that treatment can be burdensome. And in particular, the cases, I'm sure you'll both be very familiar, but it's the case of REA 2016, EWCA Civ 759, and my Lord Justice Baker's decision of Parfit, or his, and that's 2021 decision, EWCA Civ 362/61. That's also been reflected in other judgments, most recently cited in Mr Justice Poole's decision regarding the REIN, where an individual had been in a coma for 6 months. And again, there was a question mark as to whether or not he was experiencing pain. So it's a recognised fact that even if that, you can still make conclusions regarding burdensome treatments. And so on that note, unless there's anything else you wish me to address you on ground 1, I was going to move on to ground 4.
No, ground 4 then.
Thank you. So, in respect of ground 4, it's been put the following way: it's an error of law to conclude it's appropriate to cease treatment for someone with a low burden of care and no express wishes not to have care. My submissions in response to this are twofold. Firstly, there's no error of law, and secondly, it's wrong to characterise PC's condition as being one of a low burden of care. If I may start with the latter point first, so that the burden of care argument. Well, it's important to look at the judgment on this, and whilst it's right to identify that PC's condition is stable and that she's not perhaps receiving highly interventionist treatment in the form of maybe artificial ventilation, dialysis, other things like that. So one characterises treatment in that way. However, if one looks at the judgment and the evaluative findings that Mr Justice Cusworth reached on this, in particular, they start at paragraph 57, and that's page C59. So this is part of the analysis of his judgment. So it's not simply summarising the evidence he's heard. So at the top of page C59, he says, I also have to take into account the views of PC's carers. While the suggestion that PC's condition is actively deteriorating is not made out in the evidence, I accept there's no prospect of any tangible improvement in her condition. It's striking there have been no observations of any comfort or pleasure reactions in her, and that staff at the RHN have been themselves upset by the distress that her daily life can cause her. On this point in particular, he then talks about how her suffering can be alleviated by morphine or antidepressants and increased sedation. He reaches a conclusion it's unavoidable that there is simply no evidence that PC experiences offer her any positives. There's no evidence of any enjoyment of life. The only evidence is of her exhibiting discomfort and pain. And he distinguishes the case of W&M, which I understand reading the head note, and I've read the case a long time ago, but certainly reading the head note in preparation for today, again, there was clear evidence I understand from the carers about, and I can take my lords, my lady to it. But going on with the judgment, paragraph 58, I do bear in mind there's no need for PC to receive any especially burdensome treatments. However, it's sad to note that just the everyday functions of caring for her are seen to cause her distress by the nursing staff, which distress is only partially masked by medication. He accepts the point that she's recorded as being stable, but that appears for the most part to be stability generated by sedation and not equivalent to any amount or any element of comfort. Pausing there, so you've already identified some of the burdens of PC's care. There's also the fact of her muscle spasticity, which leads to contractures and requires stretching, I understand, on a daily basis. She does require occasional suctioning, which is also is certainly reported by patients who are conscious and able to communicate as being very painful. We also have Professor Wade, whilst he said he wasn't a nursing expert, but he was asked about this. And his evidence was
D109.
thank you, my lady. I've actually quoted it in my D109 D to G, and in response to being asked questions about this, he said, I think you've mischaracterised some of the burden of care that she has to receive, which is fairly burdensome. They don't report it each time. They care how much she might cry or resist being looking at me and grimacing and so on, because that's an everyday occurrence. So this is in response to questions about her being stable. And the fact is, in the medical notes, it doesn't set out every single occasion in which she's grimacing. However, or crying, that he does conclude that the burden of care is an everyday occurrence. Every day she has to be cleaned, every day she has to be stretched. And that weighed very heavily in the determination of Mr Justice Cusworth, as he identifies at the conclusion of his judgment. In particular, paragraph 64, that's page C61, and over to page C62. Where he says the benefits of continuing CANH are clearly outweighed by the significant burdens to her continuing condition. And this is where he did make a finding. It's right to recognise this, that he was satisfied based on what he'd read and what he'd heard about PC, about the woman she was before her tragic brain injury, that in his evaluative conclusion that she would not wish to continue with life in her current condition. And in my submission, that was a finding he was entitled to make on the evidence he heard. And it would be a step too far for this court to interfere with that. The court may perhaps disagree or may think it may have reached a different conclusion. But this was based on the evidence he heard from a range of different sources. So, in submission on that point, I'd say that it's wrong to characterise PC's case as being one in which she had a low burden of care. In terms of the error of law point, in my submission, it would be inappropriate to add a gloss to the established legal framework. It's set out in section 4, and then also by the highest appellate authority in Aintree. It's been long recognised that each case is intensely fact-specific. It's wrong to try and impose a particular exception or cases where patients may fit this particular cohort. Each case is different and must be decided on its own facts. My own friend relies on the case of Briggs. In short, my submission on that is that Briggs does not say what is being suggested, which is that you require compelling and cogent evidence about an individual's specific wishes and views before reaching best interest decision that it should be discontinued. That's the way it's been put in my submission. That's not what Mr Justice Charles was saying. Bear in mind, in that case, he had the more unconventional situation where you have the family who were applying on the basis that it would no longer, in Mr Briggs' case, it was no longer in his best interest to continue with treatment. And you then have the CCG, as it then was, now ICB, resisting by saying, well, no, this isn't quite right, and we don't think that's right. And in response to a specific submission that the absence of making an advanced decision should be read positively as a patient making a conscious choice to say that they would want their life to continue. That's what Mr Justice Charles was responding to. And if we go to, I can take you to the, I've set it out already in my skeleton. The point of principle relied upon by Mr Lawson is at paragraph 71
Of Briggs.
of Briggs, which is in the authorities bundle on page 40,
Which you cited in your
which I have.
summarised paragraph 69 of yours.
Yes, but it's important to read the entirety of paragraph 69 through to 74. I'm not going to do so now, but it's, and you'll see,
Which paragraphs?
so it's 69 through to 74, it should be read as a whole, where he says, my disagreement is founded on the point that, and his disagreement is in response to the submission made in the paragraph above. Counsel for the NHS Trust and CCG, that a person is not made an advanced decision with an indication that he or she would not have done so if they thought about it, and that such inaction indicates a decision or wish that they would want life-sustaining treatment to be carried out. So he's responding with specific submission. Furthermore, he goes on to say that in any event, such decision is very fact-sensitive. And he goes on at paragraph 74, which is perhaps more akin to the present case, where he says, I've deliberately not tried to set out how convinced the court has to be about what he would have decided to do if he or she was able to do, because in my view, the weighing exercise is so case and issue sensitive and is not a linear or binary exercise. And because here I'm sure in the sense that I have no reasonable doubt on the decision that Mr Briggs would have made if he was able to do so. It's recognising the sensitivities of the evidence before you. So to elevate paragraph 71 as being a point of principle that the court is required to have cogent and compelling evidence before reaching a view regarding the continuation of CANH or other licenses in my submission is simply not made out, even on when you closely read the ratio of Briggs. In conclusion, the ICB would submit that there's no real prospect of success for grounds 1 to 4, and that permission should be refused. Furthermore, there's no circumstances in which grounds 3 or 4 should also be considered. Certainly the grounds of appeal and the submissions from my learned friend do not disclose any. What I am asked to submit, which is that if the court agrees and refuses permission, it's slightly premature, but my learned friends and the parties are aware of this, that the stay of the order would effectively also be discharged. For the court's benefit, I'm informed that RHN would propose that the process of ceasing CANH should commence no later than the 12th of August. And so if my lady, my lord are with me and refuse permission, then we would invite the court to vary the order of Mr Justice Cusworth to reflect that. Certainly that the process should be undertaken or commenced no later than, if I suggested 7 days after those dates, because it provides some wiggle room either side. But certainly that is what's proposed if the court does ultimately receive permission. If I may just turn my back.
Of course.
My lady, my lords, I have had some further information regarding the PDOC guidelines, if that would assist, in terms of submissions I was making around what they say, or rather what they do not say. So section 4, which I've taken you to already, that deals with steps to be taken before best interest decision making for CANH. And at page 195,
So 4.7.1, we looked at that.
yes. And in particular, going down the page, establishment of the level of awareness. And then over the page to 196, the conclusion under that section is, for this reason, expert PDOC assessment in accordance with the guidance set out in section 2 required to provide a detailed evaluation of their level of awareness of themselves or their environment, and to record any trajectory towards future recovery or deterioration. So that's the purpose. It's not saying that it needs to be repeated in the event of a disagreement around best interest.
Well, that paragraph begins with the words "for this reason."
Yeah.
I infer that the reason are the two, well, either both of the reasons or the second reason. The second reason is the trajectory of change rather than a diagnosis of VS or MTS per se.
Yes.
So in order to say whether there's any trajectory of change, you have to have a sequence, don't you?
Yes.
Is it your submission that providing the evidence is clear from the tests that have been carried out, that the sequence
Yes.
is that the trajectory, there is no trajectory of change, there's no need for an immediate, under this guidance, there's no need for an immediate.
Yes.
And a repeat or update.
Yes. Following that intensive testing period to begin with, and then a further 6 months, and then every 12 months after that. That, as if you'll see the full PDOC records, E1 to 49 in the core bundle, they set out the annual testing, that they set out the trajectory, and also if there is any demonstration, whether from family or carers or those that see PC on a daily basis, of change of responsiveness to her environment, then again that would prompt further assessment, and it's just simply not been the case for her. In terms of the role of the second opinion doctor, again, a page, if I may just simply read this because that might be quicker rather than taking you to the particular point. So I'll give you the page references. Page 199 of the bundle.
Sorry, page.
199 says it's and it's to do with the role of the second opinion.
Second opinion clinicians should carry out their own examination of the patient.
Yeah. And then at the bottom of the paragraph under those bullet points, it's the sentence starting, neither do they need to perform an independent evaluation of the level of consciousness, but this has already been done and documented in accordance with the recommendations.
This is in the context, if we go further up the page, of where the family and doctors all agree. Because
Well,
that's why Professor Wade came in the first place, because at that stage everyone agreed. And so, in compliance with the guidance, quite properly,
Yes.
Professor Wade was asked to come in, give a second opinion,
Yes.
which he did, and that
Yes.
that formed the basis of his first report.
Yes. It's the role of the second opinion doctor would also apply though if the family were to disagree. So that if the clinical view was from those caring for PC on a day-to-day basis was such, and then they proposed that actually it would be in her best interest to cease CANH or other life-sustaining treatment, then it would still prompt, my understanding is, and the family were to disagree with that, it would still prompt an independent second opinion. And then finally, page 145 in the bundle, the authorities bundle. Which is under the heading long-term monitoring and repeat evaluation. It repeats the same point I've already made, which is under the box. It's the third paragraph under the box. It says formal clinical evaluation for the purposes of treatment planning and best interest decision making should be undertaken at 6 and 12 months post-injury and annually thereafter until the patient either passes away or emerges from PDOC. And it sets out the figure there. So those further references in my submission support the view that the assessment in this case for PC was in accordance with the guidance and was not necessary in order for Mr Justice Cusworth to reach a best interest decision. There was no deficiencies in the evidence that's before. Unless I can assist you any further, please.
Thank you very much. Ms Watson.
My lord, my lady, given the very extensive submissions you've heard already, I hope I can be relatively brief. It is obvious to all, I think, and those watching, that I appear on behalf of PC herself through her litigation friend, the official solicitor. This is, of course, a very sad, incredibly tragic case, and it is one that the official solicitor herself has been personally involved in. And so when I come to address the court on ground one, it is important to start with the official solicitor's position when the evidence was first disclosed, and that was to examine with care whether there was sufficient evidence before the court in order to carry out the essential function of analysing PC's best interests. It's set out at paragraph 19 of my skeleton argument, but it is clear that the official solicitor felt at that stage that the evidence was not sufficient and wished to ensure that there was an up-to-date assessment by the second opinion doctor, Professor Wade, and a request was made to that effect. The official solicitor also requested evidence from Dr. B, who is a recognised expert in prolonged disorders of consciousness, and that was provided in due course by the ICB. The official solicitor also asked for copies of the assessments, which, my lords, my lady, you've now been taken to. And I hope this isn't a repetitious point, but it's important, I think, to understand the chronology. We were told that the application or decision was made to apply to the Court of Protection on the 10th of July of 2023. When considering whether further assessments were required, it is important to note that the additional WIM and CSR-R
After that
tests
date.
were October 2023. The official solicitor cannot know whether those tests were going to be undertaken in any event, or whether they were undertaken as a consequence of what is set out in the guidance. Because if I may go back to page 131 of the authorities bundle, above the set of bullet points, which, my lords, my lady, you've been taken, is a paragraph which starts the WIM and says the WIM and the CRSR are suitable for monitoring over an extended period of time, whereas the SMART provides an in-depth assessment with opportunities for deep dive investigative exploration into specific behaviours. And so, again, if we go, I'm sorry to take this in reverse, up again to the paragraph above that, where the guidance deals with consistency for recording of longitudinal outcomes, that paragraph finishes with the CRSR should be used as the minimum requirement. And so it appeared to the official solicitor, certainly, that not only the minimum requirement had been met for longitudinal assessment, but there had been additional assessment using the WIM tool. And it didn't, therefore, appear to the official solicitor at that stage that it was necessary to request any further evidence in the form of assessments. The official solicitor also considered carefully whether or not any independent expert evidence was required, and had regard to the limited pool of experts in prolonged disorders of consciousness. Professor Wade is someone at the top of that list, as is Dr. B, and that, I hope, is apparent when one looks at those who were responsible for drafting the guidance, and that can be seen at page 92 of the authorities bundle. Professor Wade was co-chair. Dr. B comes not too much further down the list of contributors. And it was felt that Professor Wade, in this case, could fulfil the role, essentially, of an independent expert, as he was not one of the treating team. He did not work at the RHN, and he was a known and experienced expert who has provided reports in these sorts of cases over a number of years. The role of the second opinion doctor is set out in some detail in the guidance, and in particular, you've been taken to one part, but also at pages 196 and 197, it is made clear that the second opinion doctor should be a senior clinician
Sorry,
who is independent. I'm sorry.
196, where?
4.7.2.
Oh, thank you.
There is a number of bullet points in particular on 197, which, when in the context of external scrutiny, refer to a senior medical consultant who's not directly involved with the patient's care, who has expertise in best interest decision making, and who approaches the question from a neutral stance. Reference to the one consultant being an expert in PDOC evaluation. Well, in this case, there were two, Professor Wade and Dr. B. the independent consultant should see the patient in person, which Professor Wade did twice, a year apart. And as already submitted, a seasoned, if I may call him that, expert in these sorts of cases, well used to providing expert evidence to the court.
So he provided the second opinion before the application was made.
He did.
The OS considered whether or not any further expert should be instructed, decided not, it was appropriate to go back to him.
That's right.
And then she sent the email, which we have at, or, well,
D1 of
D1. Is that the actual email, or is it the, is that what went directly to Professor Wade, or is it a sort of summary of what was put in there?
that went to those at the ICB who we understood were responsible for commissioning a further report from him. I don't know whether that was then sent on to him in that form.
At D1, we have the questions which the official solicitor thought were appropriate,
Yes.
including B, A, whether there's been any material change, B, whether there is value in further investigation,
Yes.
C, carry out a re-examination and or reassessment of her condition. That's what he was asked to do,
That's right.
and that's what he did in the second report. And in answer to the question whether the further investigation was required, 534, page D44, answer no.
He says no. So before the matter began, the official solicitor felt there was a sufficiency of evidence, and insofar as the application that was made for an adjournment to obtain further evidence did not consider, having heard the evidence of Dr. A, having heard the evidence of Professor Wade, that any further evidence was necessary, and so did not support, in fact, opposed that application.
Was it put to Dr. Professor Wade in evidence that there should be a further WEM or CRSR assessment or anything like that?
My lord, it was, and in fact, that one can find at D66E.
You say not much, don't you? You said that one of you said, and you or Mr. Haddon said there was some, but not much, and Mr. Lawson disagreed. D66.
D66. Mr. Haddon's questions, I believe.
Sorry, I was leading astray there. So this is the question of what was Professor Wade specifically asked whether there should be a further Williams/CRS/R.
Yes, and
Smart.
the closest the question came to that was Mr. Haddon at D66E, who's referring to section 2.7.1 of the guidance, which says many patients in PDOC who are in long-term nursing home care have never had a formal assessment of their level of consciousness according to the guidelines. And he asks whether that describes PC, or whether she'd already had that assessment. He said, yes, she had them. That doesn't describe her case. That was written, as I'm sure you realise, when you have a large group writing guidelines, there are disagreements and statements made based on what people have experienced. It's certainly true that 5 years ago or 4 years ago, when these were written, there were many people who had never had it assessed. But within this, there is agreement that somebody who has been observed in a care home with good observations over 20 years, actually you don't need to do the assessment because you've got lots of observations, and observations made by clinical staff are at least as informative and often more informative than the formal structured assessments. But it was to encourage people to think about doing it. The submission Mr. Haddon made.
I think possibly the next question and answer are even more perfect.
Indeed. So by the time you completed your assessment, did you think any further assessments were required? Oh, sorry, by the time you completed your addendum opinion. And he said, I did not, because first of all, there have actually been many structured assessments which people see as being more robust. And he repeats, but more importantly, she'd been in a setting where care staff were familiar with looking and observing and writing about people. People who work in prolonged disorders of consciousness would have remarked upon and detected behaviours that would have indicated awareness. So Professor Wade's evidence, in short, is that there had already been a sufficient number of structured assessments. But on top of that, she had been observed by specialists in a setting which would have identified any change of trajectory. none had been identified on the evidence. And insofar as my learned friend then relies upon a change of evidence by Professor Wade.
Before we move on to that, forgive me, was it then submitted to Mr Justice Cusworth that there should, despite that evidence, nonetheless be a further structured assessment
My lord, yes.
by Mr Lawson?
Yes.
In the light of what you're coming on to now, is it? The claim
My lord,
change
but perhaps I could take my lord to the application for the adjournment. If I'm right, no.
Or was it an application for an adjournment because Professor Wade had changed his tune, so it was said, or on the grounds that there hadn't been a formal assessment in recent times and there should have been?
It was put on both bases. So there was an application which came before the hearing on the 22nd of April, and that is found in the supplementary bundle at B1. And then there was a second application which came later, yes. Was in fact supplemented by written submissions from Mr Lawson at B7. The application notice begins at B1 and the grounds are at B6. So, as the court will see at this stage, the emphasis was on the insufficiency of assessments.
well,
The application developed as a result of hearing the medical evidence. That the way in which the application was initially dealt with by Mr Justice Cusworth was to ask, well, what is it that you are really saying is needed? Should we not wait to hear from the medical witnesses before a decision is taken? And that was a course of action proposed, in fact, on behalf of the official solicitor, agreed by the judge. And then at the end of the evidence from Dr A and Professor Wade, the application to adjourn to obtain further expert evidence or to obtain expert evidence was renewed and supported by written submissions from Mr Lawson at B7 to B10, dated the 25th of April. And in the course of oral submissions, greater emphasis was then placed on the purported change of position by Professor Wade in respect of pain experience, as we've been calling it. It's said by the appellant here, as it was there, that more medical evidence was needed to consider and respond to Professor Wade's change of position, and in order to quote, triangulate the evidence.
Yeah, I didn't understand that.
I'm afraid, my lady, I'm unable to assist, but that was the way it was put to Mr Justice Cusworth. But the position the official solicitor takes and took in the court below was that there was an opportunity to consider and respond to Professor Wade's change of position. There was no unfairness in the decision that was taken not to adjourn, because there was before the court an alternative view the court had Professor Wade's first report and his second report, where first pain experience is very unlikely, pain experience is unlikely, and the court was able to appreciate the evolution, as we described it, of his evidence orally. But the court also had the evidence of Dr. A, and I've set that out in our skeleton argument at paragraph 28. It's taken from my note. We haven't, I'm afraid, got an agreed transcript. That's paragraph 28.1, page 15, if you have it separately. Dr. A was asked about pain experience in light of her report of pain behaviours, and she said the diagnosis is MCS minus, which means on the lowest end of MCS. So there is a possibility she had a tiny bit of awareness of pain and maybe other things. In my observations of her, I've seen very little deliberate responses. Dr. B's evidence was also before the court in written form and is before this court in the supplementary bundle. At D26, he addresses his view, paragraphs 41 and 42. He is more aligned with Professor Wade's starting position, in that he says her level of consciousness and therefore sufficient cognition to experience pain at an emotional level was not supported by continuous assessments and observations. It goes on in 42 to say these were interpreted as stereotyped, repetitive, in a similar pattern without any adaptive function, arousal phenomena, generated and perpetuated by minimal stimuli or with no stimuli. This was a disproportionate response from an extremely narrow behavioural array. To interpret all of these behaviours as experiential distress would be to misinterpret them and overtreat with medication. And then he goes on to say that that can cause confusion amongst staff and family members. So there was an alternative view before the court, and indeed there was, as the court is now very well aware, rigorous and detailed inquiry into Professor Wade's opinion on awareness and experience of pain by Mr Lawson. And you have that in the transcript at pages D71 all the way through to D110. What further testing, what one asks of the evidence, could be carried out? Well, of course, what one can ask questions for as long as one has questions, but there must come a point where the court says, you know, I understand the issue, I appreciate what it is, and I have evidence on it, and that is the position reached by the judge in the court below. As set out at paragraph 26 of my skeleton, the judgment acknowledges at paragraphs 40 and 42 all of the evidence. So we have in the core bundle C52 to C53, those passages in the judgment which indicate that the decision to refuse to adjourn to obtain further expert evidence was taken in the context of all of the available evidence as to PC's diagnosis, as to PC's level of functioning, and as to the prospect of further evidence providing greater clarity of PC's experience of pain. I needn't take you again to paragraphs 51 and 52 of the judgment, but it is plain that the judge made a finding of fact that there was no uncertainty in respect of PC's diagnosis, given the testing that had been carried out to date. There was no available evidence or any evidence to suggest any real prospect that PC may be functioning at a higher level than all of the previous assessments had indicated. and a finding of fact at paragraph 52 that no amount of further assessment would provide a definitive answer to the question whether PC is capable of experiencing the pain that her outward behaviour seems to manifest. The official solicitor's submission is that there was no unfairness caused by refusing to adjourn to obtain neurology evidence, given those findings of fact, and the judge's assessment that further neurology evidence is unlikely to change the already broad canvas of evidence on those topics that were before the court. Unless there are any other matters I can assist with on ground 1, I'll move now to ground 4.
Yeah, please do.
It is our submission that this ground has no real prospect of success for 3 key reasons. I can take them, I hope, quite shortly, in light of the submissions you've heard from Mr Haddon. First, it is patently clear from the judgment that the judge approached the best interests analysis from the appropriate starting point. That is, that the sanctity of life is a fundamental principle. He started there at paragraph 18 at C43. And he plainly kept that in mind throughout his judgment and in his conclusions at paragraph 62 on C60. And thus, in our submission, paying due and lawful respect to the sanctity of life. Secondly, it is submitted that Briggs did not establish any immutable principle that, absent compelling and cogent evidence that P would not want treatment to continue, the sanctity of life and the presumption in favour of continuing life-sustaining treatment must prevail. My learned friend Mr Haddon has taken you to a number of passages in the Briggs judgment and has urged upon you to read paragraph 71 in context. May I take the court not to paragraph 69 to 74, but to paragraph 60, which is at page 39 of the authorities bundle. That Mr Justice Charles was laying down no immutable principle is made clear when he says at paragraph 60, the weight to be given to a conclusion on what P would have done for himself or herself in the past or in the present if P was able to make the decision will be very fact sensitive. And if one goes back to the page before, page 38 and paragraph 57, Mr Justice Charles is effectively making clear that neither P's wishes and feelings nor the presumption in favour of preserving life is determinative of the best interests test. That's set out at 57, but perhaps made much clearer at page 46, paragraph 121. There, Mr Justice Charles says, as I have pointed out earlier, P's wishes and feelings, and so what P would have done if he or she was able to do so, is not determinative of the best interests test. The same applies to the very strong presumption in favour of preserving life, and this is shown by the earlier MCS cases in which, unlike in a PVS case, there is a balancing or weighing act to be performed, and conclusions that because of a person's clinical condition or illness, that continued treatment would be futile, overly burdensome, or offer no hope of improvement or recovery, have been important factors underlying the decisions that it is in the best interests of a person to withdraw life-sustaining treatment. And the third and obvious point already made by Mr Haddon is that the judge did not find as a fact that there was a low burden. The terminology used is different. He described her as having a significant burden by virtue of her condition. He described the burdens of her condition as significant in paragraph 64, to which you've already been taken, but also made clear that he did not consider the burden of care to be low in paragraph 62. That's at C61. sorry, that's at paragraph C62.
When is it? C.
Sorry, C60 at paragraph 62. I'm having great difficulty with numbers today.
No, well. See, paragraph 60.
Paragraph 60.
C60.
Paragraph 62, my lord. C60.
Oh,
Where is the phrase about burden of care?
sorry, my mistake.
The phrase about the burden of condition comes in paragraph 64, my lord. At the bottom of C61, in paragraph C64, the judge states that I agree with the applicant ICB, with the RHN and with the official solicitor that for PC, the benefits of continuing CANH are clearly outweighed by the significant burdens for her of her continuing condition. But he had dealt with the burdens of her condition in paragraph 62 before coming to that conclusion. And if one starts halfway down the paragraph 62 on C60, he says, however, in trying to interpret the value to her of her current existence, I cannot avoid the conclusion that her life has not since 2020 and will not, going forward, be one that affords her any measurable degree of pleasure or even contentment. Further years of life may be of value to anyone, however disabled, if they are able to derive some positives from their existence. Very sadly, the only evidence that I have of PC's condition and mood, when not sufficiently regulated by medication, is of discomfort and the experience of pain. One of the striking features for the official solicitor, which led her to support the application in this case, was that there was no evidence before the court of any behaviours which one would interpret as indicative of comfort or pleasure. But there were a number of witnesses who gave evidence to the effect that a PC presented in pain or discomfort, and one of the most striking was the evidence of PC's mother, MC, who wasn't describing her visits as eliciting any signs of comfort, but described her in quite striking terms as crying and looking at her with sad eyes. And that clearly carried weight for the judge. And the evaluation that he made of the burdens of her condition was one that was open to him on all of the evidence. It is our submission that it is quite clear from the judgment below that PC's best interests was approached applying the proper legal framework, which had in fact been agreed by all parties at that final hearing. The judge had followed established legal principles, and he made no error of law, no error of fact, no error in the exercise of his discretion, and there was no procedural or other irregularity that can be identified on the face of the judgment or when one explores the evidence before the court. And for that reason, it is our submission, and we align ourselves with the ICB in that respect, that permission to appeal should be refused. The appeal has no reasonable prospect of success, and there is no other compelling reason why the appeal should be heard. And insofar as my learned friend has argued that grounds three...
We've heard it now, Miss Watson, in effect.
Yes,
Yes.
yes. And insofar as my learned friend argues that grounds 3 and 4 give rise to a compelling reason, all that we say in response to that is covert consciousness as a concept isn't new. Awareness, consciousness, a patient's experience of their condition, however one describes it, is a matter to be considered as part of the wide canvas of evidence when any court is assessing best interests. It gives rise to no compelling reason why the appeal should be heard. And similarly, in respect of ground 4, there is no need for any further specific guidance for a discrete category of case. The Supreme Court in Avery has provided such guidance as is appropriate in what are exquisitely fact-sensitive cases. my lord, my lady, you've been taken to the passage in NHS and Y, the 2018 case in the legal principles. I simply direct your attention again to paragraph 119, which is quoted at A12 of the supplementary bundle in paragraph 4, in which Lady Black does not see any justification for carving out a separate test or category for PDOC cases. And unless I can assist the court any further, those are my submissions.
Can I just ask the point raised by Mr Lawson about GU?
Yes,
Do you have anything to say about that?
my lord, the matter came before Mr Justice Hayden in the case of GU, which caused concern to the official solicitor because there had been quite some delay in that case before any assessment had been carried out of GU's best interests. And it transpired, as a consequence of exploring matters in that case, that GU was not the only patient who had not had a proper assessment, a timely assessment of best interests. And as a consequence of that, there have been, we understand, some quite extensive changes at the RHN, which will lead to a number of cases coming before the court. I am aware of, in addition to this case, one other case in which judgment has been given, and I am aware of another case that is coming back before the Court of Protection in October or November, but I understand that there will be more.
These are cases in which the official solicitor has raised the question, that's right, that there, as to whether there have been sufficient up-to-date assessments of the best interests of patients in a PDOC situation who've been in that situation for some time.
Yes, it's the timeliness of the application to the court where there is no agreement or there is a finely balanced decision to be made that has caused concern to the official solicitor. And that was the issue that was raised in this case.
Did Mr Justice Hayden make any comment about it in his judgment?
He did. In fact, he provided a separate judgment in which he was heavily critical of the practices that had become embedded at this particular hospital over a number of years. And it was in response.
Not in the main judgment, then.
I believe there was a secondary judgment. He required the attendance of the chief executive, if I'm right, in order to explore precisely what had happened.
So it's my fault for misunderstanding. I got an impression that there was a change of policy about the type of patient who was going to be brought to court.
No. The process by which best interests were going to be regularly and comprehensively assessed by the hospital, and where the decision is finally balanced or there is disagreement with family members, the process by which the matter will be brought promptly before the court. That was the review that was undertaken. Thank you.
Mr Lawson, back to you.
Lady, I propose to be really quite brief and to limit myself to true points of reply.
Yes.
And not to seek to re-express anything I've said in the light of how things have been put, so to speak, to carry on the argument. So I propose to be relatively brief. I'll say that it may be, however, that at the end there are some specific points that you wish to raise with me.
Right.
So we went back, just into my notes, we went back to 195, 196, and its reference to section 2. Mr. Haddon, I think, Ms. Watson was asked whether there were challenges to the number of and approach to the assessments to Professor Wade in evidence. My Lord Justice Baker said that it had been said that there hadn't been a lot of challenge. the point in the Skeleton argument about that relates to covert consciousness.
Okay, fine.
Yeah.
I withdraw that.
No, I'm not.
But now you raised it, did you cross-examine Professor Wary about
Yes.
the question whether or not there should be further structured framework assessment?
Yes, and I can give you the references, and of course we can go to them, but just the references. D65E, there's four of them. D65E, D79A to E, D80G to H.
D79.
65E, 79A to E, 80G to A.
And 85F to G, and that's the four. And we had his evidence in chief that he thought that the number appropriate, and I challenged whether that was compliant with the guidance. And rather than just repeating the straight question whether that was compliant with the guidance, took him, I think, to the section we looked at where it said there should be a number of the assessments, that it should be done by a multidisciplinary team. I mean, leave aside obviously whether or not the points are right, the question of whether there was a proper assessment of consciousness was raised, and the application to adjourn also said that there should be, check that, also said that there should be, I think we went through earlier the particular paragraphs, but said in terms there should be further standardised assessment.
Sorry, what were we just reading from?
That was from the application to adjourn, which is B7.
Okay, yes,
yeah,
yes.
B7 to 10.
25th of April,
Thank you.
written notice.
Sorry. So there, thank you for showing us those four references. You put your case, and Professor Wade didn't agree.
He didn't agree, and one of this is why the other reason we opened in the adjournment application with that he's departing from the guidance, and that the guidance did require a greater degree of assessment than had been carried out. And that was the application that the court didn't have enough before it, and hence should get more evidence from a neurologist, and by doing further assessment. There is an implicit assumption underlying the points that are made about pleasure, of course, which is that pleasure is observable. We're talking about pleasure behaviours. Because underlying that is the idea that when someone is experiencing pleasure, you can observe it. You obviously you can see someone smiling, but pleasure behaviours there are fewer pleasure behaviours than there are pain behaviours, and contentment all the more so. It was said by Mr Haddon, I believe, that it was concluded that PC wouldn't wish to continue. In my submission, that isn't what the judge concluded. This one probably is worth going to. C58, para 56. At 55 and 56. Yeah, it's then the conclusion really of that discussion is about 6 or 7 lines up from the bottom of 56. Considering the competing argument, it is impossible to form a conclusive view about PC's likely attitude here.
Well, you never can you? In the case of this kind, a conclusive view, how could you?
I mean, that may be right, but the contrary position put by Mr Haddon, in my respectful submission to Mr Haddon, is certainly not right. One can, the Briggs case may be an extreme example, but the finding of the judge there was, I think, something like he was a man of action and a courageous man and wouldn't have wanted to live like this.
Yeah.
So in that sense, quite specific findings were made that that particular person, Mr Briggs,
We have paragraph 64 as well, where the judge took into account all the information, particularly in the mother's statement. I'm entirely satisfied with all I've read and heard in her written material and the limited, brave oral evidence she felt able to give. But he said, I'm satisfied she wouldn't wish to continue with her life in her current condition. So what he's saying is that I haven't got sufficient evidence to form a view, precisely what, a conclusive view, what her attitude would be here. But having listened to all the evidence available to me, he makes a finding that she wouldn't wish to continue life in the current condition.
My lady, if I may rise just to assist, it's important to see the whole of paragraph 56 because it's addressing a particular point about what PC's views would have been in respect of the impact to her family. And the paragraph starts like that, so what other factors that PC would be likely to consider? And then he says, so it's important to read the whole paragraph. It's addressing a specific point regarding her views on.
All right, Mr. Haddon. Well, we will read the whole paragraph.
I mean, on that basis, 55 above also says there's very little evidence about how she would have reacted. We've been to Dr. B's witness statement. Ms. Watson puts it and says, "Oh well, it's that." So there's contrary evidence, but in fact, what it brings out in our submission is the extent of the change by Professor Wade. Dr. B hadn't seen PC for 3 years in a clinical capacity by this point. And then finally, my lord, the question about GU. The point we make about the general impact is that where GU is spurring organisations, the one it's addressed to and others, to review patients who haven't been reviewed, often perhaps because there's nothing to bring about that review. I mean, often people are stable without their relatives suggesting it. That will lead to a change in the type of applications being brought before the court, from those which were crying out to be brought before the court to positions which hadn't naturally fallen into that category.
Right, you're asking us to start giving some guidance for cases that may or may not come in the future.
Well, the evidence below, which was very lengthy, was that quite a number of cases were really everybody was being reviewed, and a number of cases were progressing.
Well, the one lesson surely from doing these cases, as at least Lady and I have now for longer than we care to think about, is that they're all fact specific. And the dangers of giving guidance about this is, well, for my part, I'm concerned about being too prescriptive.
Because what you're asking us to do is then potentially you could be suggested that one's being asked to give greater weight to some features of the best interest analysis than others, which in turn would mean effectively putting a gloss on the Mental Capacity Act. I don't think that would go down very well in the Supreme Court.
I think well, yes, I think in fact, I'm sure Marion Taylor says that position in the entry.
One of the cases says the act is clarity itself or something,
Yes.
doesn't it? I mean, we're looking at the particular application to this patient and questioning if has there been a basis to go against the sanctity of her life
That I understand.
in the limited circumstances.
That I understand. Your request for us to launch into guidance and treat this as a test case. So. find more difficult.
My lords, my lady, may I just turn my back just for a moment?
Of course.
Thank you. If I may, I'll just go this way.
They'll extend the stay. That's what I'm finding.
Thank you for listening to us now for the day. We're most grateful. No further submissions.
We're grateful to all of you for your very helpful submissions. Not a minute was wasted in my opinion. It's an important matter. We will reserve judgment. We will. It's not an enforceable undertaking, but we are confident that we will be able to get to a decision by the end of the month, possibly next week. We'll see. We haven't yet decided whether we will simply hand down a judgment in one go or send it out in draft. If we do send it out in draft, then Council will be very familiar with the procedure, but I have to mention it. Two things. If the judgment is sent out in draft, firstly, it's confidential to the parties and their advisors until the formal hand down. See the judgment of this court in the Counsel General for Wales's case. Secondly, it's sent out not for re-argument but for correction of typos and other obvious factual errors. We hope and trust that in the light of whatever decision we give, the terms of an order can be agreed. For the avoidance of doubt, the stay in this case continues until after we give our decision and make an order implementing it, whatever that is. Is there anything else we should be dealing with today?
My lord, in case it is of assistance to my lord, Lord Justice Baker, the GU citation 2021 EWCOP 59, 2 hearings rather than 2 judgments, a lengthy single judgment in which best interests and then the issue of delay is dealt with. I hope.
Thank you very much, Ms. Watson.
All right, available.
It was part of the report, yeah. The phone chargers, I think. Actually, no, they
for the
charge the
microphones,
microphones.
aren't
They also double up as a phone charger. It's probably a litre.
they? Do they?
Yeah, no, the phone.